Live on the news feed, your reporting continues. Now, the Pretoria High Court has struck off the roll an urgent application by Postbank to interdict the termination of the master service agreement. The bank took the South African Social Security Agency to court over the agreement, which regulates the payment of millions of social grants each month. During arguments, SASSA said it lawfully moved to end the contract due to Postbank's failures and reputational risk. But Postbank disputed this, saying the agency did not follow the dispute resolution process set out in the agreement. All right, let's talk more now about this. I'm joined by Black Sash Advocacy Manager, Hoodah Abrahams. Hoodah, good to have you, and thank you very much for coming on. How concerning is this particular matter of the non-continuation of the Postbank contract, considering, of course, where SASSA would have been before introducing the Postbank again into the mix, but also the glitches that we have been experiencing in this particular process as far as beneficiaries accessing their social grants?
Good afternoon to you and the listeners. Obviously, Black Sash has been raising these concerns about Postbank's efficiency since the cession of the contract to Postbank since 2022. So we've always engaged with both SASSA and Postbank to alert them to these challenges, because at the end of the day, the beneficiaries bear the brunt of these different issues that Postbank and SASSA have been having. The termination of the contract is obviously a concern in the sense that we're not sure what is in place in terms of ensuring that the beneficiaries receive the full cash value of the grant. In terms of SASSA, they had given notice to Postbank, and so this interdict or application is obviously just a concern when what we need to look at is how does this impact on the beneficiaries. Postbank did provide a free basket of services, so we are concerned about what that means for social grant beneficiaries, because now more of the option is to turn to banks as a way of receiving grants. Postbank will still be an option where beneficiaries can receive their grant, but we are really trying to understand what this means for social grant beneficiaries when you know that banks have a profit incentive, and how that is going to impact on the beneficiary, because you're looking at what the cost is of withdrawals, what the cost is to draw a statement, and also the question of digitization and automation, how that will impact on a social grant beneficiary.
So you're not taking SASSA at their word that says, well, look, beneficiaries will get their money. It says they must just know that. It's a beneficiary, after all, who chooses what kind of an outlet they want to go to. If they want to go to Postbank, they'll still get their money at Postbank, but they will get their money either way, all 19 million of them.
Well, we'll have to monitor that process. And I think in terms of the choice that the beneficiary has, it's not a free choice, because the choices are limited in terms of the fact that Postbank does not have a constitutional obligation in terms of what it has to do in terms of holding them to account, where there was a master service agreement in place with SASSA. That's the one concern. And the second concern is now you have different banks with different types of services that they provide. And what the issue is that beneficiaries can be lured by these private entities to buy other products, which makes them vulnerable, given the fact that they have a small amount of money that they depend on as a lifeline with the social grant, and then maybe they will then be asked to buy other products, financial products, airtime, etc., which takes us back initially when we had engaged and approached the Constitutional Court when beneficiaries' grants were at risk, when there was a private entity that was administering grants back in 2017.
Yeah, that's what has led us to this point to some extent. But when the agency says there will be no charge, I mean, is that truly the case, that they won't be charged anything? Are you fearing that there could be hidden costs, or maybe even, as you put it, the costs of unsolicited marketing?
Well, I think we don't know what the nature, if first of all, there are agreements with banks and SASSA. For example, with the Postbank, there was an agreement in place that they could be held to account to in terms of what service they had to provide and also what they could charge a beneficiary. And like I said, there was a free basket of services. With the private sector and the different kinds of banks, we don't know what the nature of the agreement is and what agreements are in place. So I think that's the bigger question.
Yeah. When we then look at what SASSA is arguing at the court, saying, well, this has been a matter of a dispute in how you're handling this contract. And we know there have been glitches and delays in releasing of monies, and sometimes your beneficiary will stand in queues for days, not get their money, and so on and so forth, saying this is a reputational risk. Do you sympathize with that? Is it a justified view by SASSA?
Well, I mean, we, in our monitoring, we have seen it for ourselves that the beneficiaries have stood in long queues. There were technical glitches. So we can confirm that that has happened when Postbank administered the grants. The question of the master service agreement was something that we took SASSA to task at the very beginning because they said it was under review since the contract was ceded, and it never came to in terms of addressing the concerns of the service, what the cost of the service was, and also with the shrinking footprint of Postbank, whether they could indeed provide the services.
So do you think SASSA is pulling the trigger prematurely? Maybe, yes, there are gaps. Yes, there are failures. There could be something that we could identify in these contracts that could help us manage these glitches. And termination
and I
is
think
not
that's
the
the
way to go.
problem. Yeah, the problem is that now there's more of a dependence on banks. And like I said before, that's the private sector. There's a profit incentive, which is a concern. On the other hand, the issues with the Postbank has been happening since the contract was ceded. So they've had time. SASSA had indicated that they had engaged with the Postbank since 2023 to alert them to these challenges. And now going to the court for an interdict when there is no plan in place as to how this will be addressed, how the affected issues will be addressed in a constructive manner. So all Black Sash is concerned about is that beneficiaries must be paid the cash value of their grant without having to incur expenses to travel long distances, and also in terms of transport costs and delays with waiting. And we're not sure, there's no reassurance of how that will happen going forward. We'll have to see in terms of what the impact is on beneficiaries, depending now on banks to be able to deliver and pay the grants.
Do you see yourself playing a role in this dispute in terms of the processes as Black Sash, maybe other civil society organizations?
Well, I think we have a right to be concerned. You know, this is something that has been ongoing since 2012 when you had a private entity administering contracts. It has then shifted where we expected to see some improvement when it was ceded to the South African Post Office. There were challenges and then ceded to Postbank. So through all this, more than 10 years, it has been where beneficiaries bear the brunt of these governance and operational issues of SASSA and Postbank or whatever entity or partner they have. And at the end of the day, our concern and our interest is about the beneficiary, considering that almost 45% of the population depend on social grants if you include the social relief of distress grant as well.
Yeah. Well, the court say there's nothing urgent here. You had 18 months to raise this matter if you wanted to raise the matter. But we're here now. It's been struck off the roll. And I suppose SASSA saying, well, we're waiting for the contract. The contract is ending anyway. From Black Sash point of view, what steps should government or the agency take at this particular point?
Again, I'm reiterating that the interest must be that of the social grant beneficiary. The Postbank was expected to be a state bank where it could be held to account in terms of constitutional obligations. And so if Postbank is not in the picture, how do we ensure that whoever is paying the social grant to a beneficiary, that they are accountable in terms of the constitutional imperative to ensure that beneficiaries have the right to social assistance and social security?
Hoodah, appreciate your time. Thanks so much for coming on. Advocacy Manager there, Black Sash, Hoodah Abrahams, with, of course, their response and reaction to the High Court judgment.